Hey everyone, my name is Nikki Donnelly and I'm an attorney with Rights and Restoration Law Group. And I just wanted to take a few minutes today to talk about a law that impacts survivors of domestic violence. And I thought it would be a good time to talk about it since it's Women's History Month. And I'm going to give a little bit of sort of background on why the law was passed, but I also want to talk about, the way it actually has been implemented since it was passed. Because as we all know, just because there's a written law in the books, it doesn't mean that it's actually being followed or applied the way it should be, or even the way the, lawmakers intended it to be. So for the purposes of this video, I'm going to call this the Domestic Violence Resentencing Law, but the public act number is actually 99-384, if anybody wants to look it up. And basically what this law did was it made it mandatory for judges to consider at sentencing evidence that somebody who was convicted of a forcible felony, meaning they were convicted of a violent crime. So if they were convicted, an example of forcible felony would be like armed robbery, aggravated vehicular hijacking, murder, something like that. If that person has evidence that they themselves are a survivor of domestic violence, that has to be considered when the judge is deciding their sentence. The other thing the law did is that it gave an avenue for a 2-year window after the conviction for that person to be able, if that evidence wasn't considered at sentencing, if the evidence of domestic violence wasn't considered at sentencing, that individual has a 2-year window to file to get a new sentencing hearing and have it considered. And the reason why, there's a few reasons why this law came about. One is that there was recognition that there is an intersection between survivors of domestic violence being convicted of crimes that, of violent crimes specifically, where maybe they were under some level of duress when they were involved in, or even potentially were acting in self-defense. So the example when they actually talked about this law and potentially passing this law in Springfield was a woman who was a survivor of domestic violence being forced by her abusive partner to participate in an armed robbery, and how that should, that participation should be considered at sentencing. So that's, part of the reason why the law was passed. The other reason why the part of the law was passed that allows that window to go back and have that heard later, have that information heard later if it wasn't originally, is because a lot of times when people are in an abusive relationship and experiencing domestic violence, they may not always feel comfortable sharing that information right away with their attorney or with the judge or with the court or with the police. It may take some time and space away from that individual for them to even recognize that domestic violence played a role in what happened, and to really grasp that and understand that. So that was the thought process behind the bill getting passed. And I do want to just give a little more specific information about who can file for the resentencing. So I'm going to just go through those factors really quickly, and then I'll get into how this actually looks as it's being played out now. So somebody can file for resentencing if they've been convicted of a forcible felony. Again, I know I'm just repeating myself now, but what I was saying earlier is that forcible felonies are basically violent crimes. So like armed robbery, aggravated vehicular hijacking, murder, things like that. If that individual's participation in the offense was related to them previously having been a victim of domestic violence as perpetrated by an intimate partner. So we'll talk about how some of this language is kind of vague and open to interpretation. But one thing I wanted to highlight is that this law does specifically deal with intimate partner violence. So domestic violence could be, child abuse or violence with someone you live with that isn't a romantic partner. But this law specifically applies only for intimate partner violence. So it has to be someone that the individual was romantically involved with. The next criteria is that no evidence of domestic violence against that individual was presented at their sentencing hearing. So no evidence is, again, one of those things where this law maybe falls a little bit short, but we'll get into that in a minute. And that individual was unaware of the mitigating nature of the evidence of the domestic violence at the time of sentencing and could not have learned of its significance sooner through due diligence. So meaning that they didn't know that this information was important. They didn't know that this would impact what their sentence would be, or that this was relevant to sentencing, and they wouldn't have any reason to know that. And that the new evidence against that individual, or evidence of domestic violence against that individual's material, non-cumulative to other evidence offered at the sentencing hearing, and would likely change the sentence imposed. So basically that it's important enough where the judge could have imposed a different sentence. And that's the criteria to get a new sentencing hearing under this law. So how this has actually worked. In some ways, this has been quite disappointing, but that's really not unlike a lot of laws when it comes to like criminal justice and things like that. That it's not just about getting them passed, it's actually how they're implemented and how that actually plays out in court. Although it seems pretty clear by the fact that the way that this statute was written, that the intent was for people to be able to utilize it even once they've been convicted. One big issue that has come up with this law is whether it applies retroactively, meaning that for those survivors who were sentenced before this law was passed, and now want to raise that claim because there's been a change in the law that allows them to raise that claim, many courts have said that this doesn't apply retroactively and have not allowed them to get a new sentencing hearing. There's a couple examples of courts who have allowed it, but it is an issue that is being litigated as we speak. So there are some cases that are being appealed right now to the Illinois appellate courts that hopefully will address this and and hopefully we'll get a good ruling that says, this absolutely applies retroactively, and that's the whole point of this law. The other big issue with this law, I would say, is that it is only specifically for forcible felonies. So one thing that I think that maybe, folks don't think about all the time is that a lot of like criminal activity or a lot of decision making is impacted by trauma, right? So a lot of behaviors may be related to domestic violence in the sense that they're either, they could be ways to cope with trauma people have experienced, or they could be, ways to get material things that are needed to escape situations of domestic violence. So kind of making that distinction between forcible felonies and non-forcible felonies, I think it just leaves out a big group of, survivors that could benefit from a law like this. And then I think the other issue is just a lot of these terms are vague and they're difficult, right? They're open to interpretation. So no evidence of domestic violence was presented at that individual sentencing hearing. So, if one thing was said at a sentencing hearing, or one stray comment was made about the person having experienced domestic violence, is that enough that the judge fully considered the issue? I would think not, but some judges could deny someone's request for resentencing just based on that. And then I think obviously limiting this to just intimate partner violence can be problematic too. I understand that was perhaps like what was, in the examples they gave when they were considering passing this law, that was mainly what they were thinking about. But I would argue that the same reasons that, apply for intimate partner violence apply for all types of domestic violence, right? Like those things impact people's ability to make decisions. They make people more susceptible to coercion and to, acting out of fear. And they traumatize people and make them, act a certain way and do a lot of things just for their own survival, right? So those are things that I could potentially see getting fixed in this law or addressed in case law as judges make more and more decisions about this. So early on when this was passed, I worked at a legal aid, and we helped a bunch of folks file these pro se. And part of it was because we wanted to spread awareness about the law, but the other reason why was because we wanted to see what the outcomes would be. And like I said, unfortunately, a lot of them have been dismissed because of the, idea that these don't apply retroactively. But hopefully we'll see more being successful. Like I said, there's some that are up on appeal right now, and I'm hopeful that we'll see some judges have some good decisions about the issue of retroactivity. Yeah, so that's just a little bit of background about the law. I'll put a link to the law itself in the description below. If people want to just read the law, it's kind of dry to read statutes, but you obviously can. Yeah, thank you.